Well. We all knew. We knew after the Darrell Brooks trial that this was going to happen. What is this? Darrell Brooks has filed, surprise, surprise to no one, a notice of intent to appeal. And this might be good news. We'll find out in a minute. He's asked for the appointment of a public defender. Now, if you don't know already, I don't know how that's possible. Darrell Brooks was convicted of 61 counts of recklessly endangering people with a dangerous weapon, his vehicle, and for each of those counts, sentenced to 17 and a half years. And on top of that, was convicted of 15 other counts, 76 total crimes. I wonder if he's going to appeal all of them. I should tell you right now, I'm Josh Sanford. I'm America's attorney. I've been a lawyer for over 20 years, and in today's video, I'm going to explain the context of Darrell Brooks's notice of appeal and what does it mean. By the end of this video, I will tell you my opinion. Is this appeal gonna make a difference? What are his chances of success? Hopefully not great. No, but I mean for real, like hopefully not great. Let's find out. If you have not yet subscribed, get down below right now. Hit the subscribe button. I have more content like this. I have other content. You'll love it. We'd love to have you. Before we look at 3 documents from the Darrell Brooks appeal, we need to talk about what is an appeal. So as you probably already know, there are levels to court systems, right? And you probably know the top court in the United States is, come on, say it. It's the United States Court of Appeals, right? You ever heard of them? They never stir up controversy. Wow. So in every state, there are multiple levels of court. A case like Darrell Brooks is going to be in what most people call circuit court. Some states it's called superior court. It's not the lowest level because there's like a small claims court and traffic court, which is at the very bottom. But this is like the main court. And then above that, in every state, there's a court of appeals and a Supreme Court. And it's the same way in the federal system. These systems are separate and distinct from each other, but they kind of operate similarly. And Darrell Brooks finds himself smack in the middle of the Circuit Court of Waukesha County, Wisconsin. And that's where he filed his notice of appeal. Darrell's appeal goes to the Wisconsin Supreme Court. It doesn't go into the federal system. It doesn't go to the U.S. Supreme Court. It just goes right up to the Wisconsin Supreme Court. Now, it's going to take a while to get there because appeals take some time. But what I'd like to do in today's video, and I'll try to keep it short, let's take a look at the 3 documents that are already available to the public about Brooks's appeal. The first document is the external or public front of the court system's docket. And a docket is really just a registry of documents that have come through the court system. And you can see if you read from the bottom up, there's an order denying defendant's motion to stay pending appeal without a hearing, signed by Judge Jennifer Darrow. This was on November 28th. So he has asked the court in a prior request if they would stay his conviction pending his appeal, which is ludicrous. I mean, that's so preposterous. So let's take a look at this notice of intent to seek post-conviction relief. Comes now I, Darrell Edward Brooks Jr., authorized representative of Darrell E. Brooks. First of all, he is Darrell Brooks.
I would like to represent myself as a sovereign citizen.
How would you describe Mr. Brooks's haircut today?
Objection, I don't consent to being called that name.
Now, he didn't know that when the trial started, but it's great that he has figured it out. But this idea that he has that he should talk about himself in the third person, it's really like so consistent with the way that he behaved in trial, but he has no idea what he's saying. No rational person would talk to someone saying that I am Josh here on behalf of Josh. You just say, I'm Josh. Now, he would never say that he's Darrell until now. I guess he's convicted and it's okay for him to admit that he is Darrell Edward Brooks Jr. So, jumping right back into it, hereby informs this court and puts this court on notice that I intend to seek post-conviction relief. Now, what is post-conviction relief? Well, there's several ways that you can try to access post-conviction relief. One is to say, we had a mistrial, we need to start over. I promise you that motion is coming, okay? Another type of post-conviction relief is, and now we're going back to that levels of court, He wants to appeal. He wants to say, oh, the terrible Judge Darrow was so mean to me, and I need a fairer, smarter group of judges to take a look at what she did to me. Wow. I have already filed the Notice of Right to Seek Post-Conviction Relief paperwork as of November 16th, 2022 in this court, and I make a request to have the assistance of counsel from the Public Defender's Office and to be notified of said representation quickly and promptly. Wow. This is like actually an answer to prayer for the judge and the prosecutors and basically everyone in America, except for the people who really enjoyed how stupid he was and what a clown he made of himself in the courtroom. I mean, the idea that he would go through that entire trial and think, I don't need lawyers, but now I'm doing this appeal and things haven't gone that great for me. Like, you know, several centuries in prison. That kind of not great. And now I want a public defender. Well, that's fantastic. I'm so glad he's asked for one. You know what I'm also glad about? That I'm not his lawyer. And actually, some of you commented about this. You were saying, like, in the comments, like, why should we care whether he has a lawyer or not? He's getting convicted either way. And my answer to that is, he debased the entire judicial system by representing himself. I mean, it like lowered the IQ of everyone who was involved in the trial to have to sit there and watch the stupidity. And just because that's his right doesn't make it right. So I, for one, am glad that some lawyer, not named America's attorney, is getting saddled with his appeal. He goes on to say, it is not my intention to bring any controversy before the court. Wow. But it is my intention to have this post-conviction relief matter reviewed and heard as quickly as possible, as there are clear errors of the law and the legal facts in this matter. Oh, are there? Well, now is as good a time of any to talk about standards of review on appeal, because he's actually bringing one up here. He's talking about clear error. So when I say standard on appeal, that means what test will the reviewing court apply to the request that's being made to figure out if they think it was right, down below, meaning, you know, the lower court, or if they messed it up somehow. And there are three main standards of review that we need to talk about real quick, and I'm going to blow through these. The first one is about matters of law. It's called de novo, which is Latin for something like new. I don't know. It just means they retry the whole thing. The second one is clear error. And the second one is abuse of discretion. The abuse of discretion, if that's the standard for which you are seeking review and appeal and reversal, you're almost certainly going to lose. That's the highest one that we talked about. The lowest one, the de novo standard, that one gives no regard at all to the decision of the lower court, and they just say, well, this is a pure legal issue, and we're going to see if you got the law right. Now, the middle standard, this is the one that he has identified here, and to his credit, he's identified the correct one, is this clear error of law or fact. Now, I don't know how that strikes you, but I will tell you what courts of appeals throughout the country hear when they read the words clear error of law or fact. They're not looking to find a mistake. They are trying to determine, was there a mistake so obvious, so egregious, that they need to start things over, that they either need to reverse it, remand it, give someone a new day in the courtroom. Now, in criminal trials, there are legal errors which can be made which have to do with evidence or burdens of proof, jury instructions, but most of the determination that's made in a criminal case has to do with the facts that are determined, meaning when a jury, in this case, sometimes it can be a judge, but usually a jury, tries to figure out like what happened, or in the case of a murder trial, did this guy do it? Did he have an intent to kill or hurt? That's a question of fact. This notion that there might be some clear error is kind of preposterous. I mean, everyone, and I do mean like everyone in America knows that he did it. So Good luck with the clear error, buddy. Just kidding. I hope he loses. Going back to his note, I have already requested copies of the circuit court case record from the clerk of the court, Monica Paz, and the circuit court transcript from the court reporter. This notice of intent to pursue post-conviction or post-disposition relief is pursuant to Rule 807.302B of the Wisconsin statutes. And then he signs it with what you and I call his actual name. So there you go. That's it. That is his notice of intent. Now, that's not the appeal. Let's be clear. An appeal is a detailed written argument that is pages and pages and pages long. And this is not it. Now, I intend to cover his appeal brief if and when it is written. Like if he actually files one, then I'm going to cover it. Now, he may not do it because just filing the notice doesn't obligate you to appeal. You don't actually have to do the work, but if you don't file the notice, then you're out of time and you can't do it. It may be the case that he talks through the arguments that he could make with appeal with his public defender and they decide not to file an appeal. Yeah, right. I mean, he's 100% going to appeal. The reality is that he has nothing to lose by appealing, right? If you know that public defenders are paid for by your hard-earned money and my hard-earned money, I'm talking about tax dollars, it costs him nothing to appeal. He's got nothing else to do besides help his lawyer with the brief. Oh, wow. I'm afraid he may have an awkward conversation with his public defender at some point where the public defender says to him,
"Yo, Mr. Brooks, the less you do, the more you help."
So I've hinted at this, but what are his chances of winning on appeal? Like to have the case thrown out or to get a new trial? They would be less than zero if the numbers went into the negative. It's not happening. And I can't move on from this point without giving a huge shout out to Judge Darrow, who really, really, really protected the record and made sure that there were no meaningful errors from which he could have any kind of a successful appeal. I mean, she cut him some slack, and you guys have pointed it out. Some of you are mad at her, some of you think that she's a hero, but I'm telling you, he doesn't have an appeal because of the decisions that she made in the courtroom. In some appeals, the loser who's filing the appeal, and I don't mean that Darrell Brooks is a loser, just kidding, he's a loser. But in some appeals, the loser wants to have the case thrown out and say, oh, there's nothing here, you can't sue me or prosecute me or whatever. And sometimes they just want to go back and redo their trial. He's going to ask for both of those things, and he's going to get neither of them. I mean, literally, he has a 0% chance of either of those. But that's what's happened. If you are not familiar with the appellate process, you might think that we're going to have more of the Darrell Brooks show on appeal. But the answer is that we're not. When you have a case on appeal, there's not a new trial at the appellate court. There are written arguments. Now, sometimes there are oral presentations of those arguments, generally limited to 15 or 20 minutes. They may not want to have oral arguments in this case just because they know how ridiculous the appeal is. His lawyer will probably ask for one, but it's not where you take witnesses or testimony. It's just a lawyer trying to explain the written arguments that they've made to the court. And it's very, very short. And let's say you file a written argument and it takes 90 minutes to read it. Your oral presentation is only 15 minutes long. You're just hitting the highlights, trying to answer questions. It doesn't really move the needle in most cases, and certainly not in this case. But Darrell Brooks will not be speaking at his appeal. He will not be answering questions. He will not be arguing anyone. If he's even at the courthouse, which I doubt he would be, he'll be fully clothed. If you think that you detected a twinkle in my eye during this video, thinking about this case going to the Wisconsin Supreme Court, you're not wrong. And here's why. Jennifer Darrow, since this trial has ended, has declared her candidacy for the Wisconsin Supreme Court. Now, in a just and fair universe, she gets elected and she is sitting on the Wisconsin Supreme Court when his case comes up for decision sometime like 6-9 months, a year from now, and she goes, BAM! And smacks him back down. Unfortunately, even if she wins the Supreme Court race, which she probably will because she has name recognition that probably no one else in Wisconsin can match right now. Most judges will recuse in that situation. You're not allowed to be on the appellate panel that reviews the trial that you conducted, but man, would that not be so sweet? It would be so awesome. So that's all we know about his appeal for now, but he's not done, and I'll follow up after he files his brief. If you cannot get enough Darrell Brooks content, check out this video here or this video here. If you disagree with me, if you think that there's something that he should appeal or that he could appeal from, drop your pro se opinion down in the comments. I want to see it. I want to know if you think I'm wrong, that there's some reason that he could get his case overturned. If you want more Darrell Brooks content, check this out. I review some of his major meltdowns in the trial, and also here, when I just try to figure out what on earth was he saying. Hey, thanks so much for watching till the end of the video. I'll be back real soon. Have a great day.